Okay. Hello, everyone. Hopefully everybody can hear me. If you're having trouble hearing me, just put something in the question and answer. So for this presentation, it's we're we're going to have a Q&A function. We don't necessarily have a chat, but we are going to have a Q&A session. So just if you have some questions during the presentation, put it in the Q&A and we'll try to answer it. I am going to have some time at the end to answer questions too. And then also, I just want to introduce myself. My name is Jon Althauser. I'm an attorney for Legal Services of Eastern Missouri. I work in our office in Franklin County. And then we have some other people that are going to be assisting, answering questions that are with us today, but mostly sort of in the background, I guess. Courtney Knoll, who presented 2 weeks ago, and Terry Lawson, who presented last week, and then also Jennifer Slosar, who is also with Legal Services of Eastern Missouri. So I'm going to still give a couple more minutes for people to join before I get started into the presentation. Okay, well, I think I'm going to go ahead and start. We have over 40 participants right now, so it's a good number to start. So this presentation is on understanding eviction proceedings in court. So 2 weeks ago, we did a presentation on, or Courtney Knoll did a presentation on sort of being a good tenant and sort of avoiding going to court. And last week, Terry Lawson and John Boyer did a presentation on our Mo Tenant Help website that allows you to generate forms for use in filing an eviction proceedings. Both of those presentations are available. They were recorded. And then next week, there's going to be a presentation on fair housing. So just to start off, I have to read, the statement here on the screen that the work that provided the basis for this publication or this presentation was supported by the funding under an award from the U.S. Department of Housing and Urban Development, which is HUD. The substantive findings of the works are dedicated to the public. The author and publisher are solely responsible for the accuracy of the statements and interpretations contained in this publication. Such interpretations do not necessarily reflect the views of the government. All right. All right. So I just want to talk a little bit first about the process of any sort of court case and sort of specifics about a written possession or landlord-tenant case. So first, you have a petition is filed, right? So that's the document that's filed with the court to resolve some issue. A summons is issued. A summons is a document created by the court, and the petition and any other documents filed along with the petition would be attached to that. The summons is served, okay? Now, the summons can be served by a sheriff's deputy. I mean, that's one of their main roles is to provide summons, service of summons. Um, it also can be served by a special process server, which is in a lot of landlord-tenant cases is typical. Okay. Um, and then you'll have a court appearance. Usually on the type of cases that we're going to be discussing today, the summons will have a return date, a date that yours should appear in court. It'll have a date and time. It'll say which court division it'll be in, and there are different types of courts appearances, and they can be uh, called different things. There's such as a setting docket where cases are not, evidence isn't heard. They just uh, pick a day, another day for a trial. There's trials or hearings or different things like that. So here's what I would say the biggest thing with um, with it. If you get served with a summons, you got to go to court. And it seems like simple advice, but in a lot of times the situation is that you may have thought you worked something out with your landlord, right? And landlord may have told you you don't need to go to court, right? But if you've been served, it's upon you to go to court. I mean, your landlord is an adverse party. He or she or they have filed something to try to remove you from your home. And also, everybody that's been served needs to go to court. So if um, you're in a relationship with somebody, husband or wife, whatever the case may be, if you both get served, you both need to go to court. I have seen it too many times where only one person shows up and a default judgment is taken against the other person. So, and you don't necessarily have to get it. Like if you're both household members, um, and you're both served, um, the summons could be served to one of you, but because you're both household members, that's service for both, right? So, and luckily now you can tell. You can go on CaseNet and you can find out, um, um, whether or not you have been served. But if the return shows that you've been served, you need to go to court. So moving on a little bit. So there are two common types of landlord-tenant actions are written possession and unlawful detainer. Okay, there are some others that don't really apply in this presentation, but these are the main ones. So written possession, it's Chapter 535, Missouri statutes. So it is what it says. The rent, your landlord claims you owe rent, and possession. Your landlord's goal is to obtain a court order to evict you. Okay. It's a pretty straightforward, simple procedure, or supposed to be. And there's supposed to be, resolved fairly quickly. Okay. So there are some defenses to the non-payment of rent. Okay. So, and I want to talk a little bit about defenses generally. So there are different types of defenses when we talk about this. So there are certain things that are like you might say, well, I don't owe any rent. I have receipts that show that I made all the payments for rent and I don't actually owe anything. So that's a sort of a defense where you're just disputing what the landlord is alleging, right? So then there are what are called affirmative defenses, which are a little bit different, where maybe the rent wasn't paid, but there's a reason why you don't owe it. Okay. And some of those, the main one that people talk about is a breach of the implied warranty of habitability. Okay. And that's where you did not pay the rent or withheld the rent because of the conditions in the home made it uninhabitable. Okay. Now, when you file a affirmative defense like this, it needs to be in writing. So you have to, put it in writing what your defense is. And, if you saw Terry and John's presentation last week, you'll have an idea of where you can find out how to do that. But it has to be in writing, and it generally has to be filed before the return date. Okay, so you probably need to file it before you go to court. Okay, now, and sometimes you may not have a lot of time because the summons only has to be served 4 days before the court date. Okay, so as far as the actual defense of applied warranty habitability, it has to be something that makes it truly uninhabitable, right? So it's not going to be something, like the screen door is loose, okay? And it really needs to be something that makes it uninhabitable. Now, when you withhold the rent and you are still living in the residence, okay, the court could require you to post a bond or put the money into an escrow account for the amount of rent owed. Okay, so if you're going to withhold rent because of the habitability issue, it's best to make sure you have to not spend that on other things. Now, that's not always possible. I understand that, but if you go to court and you make the implied warranty of this affirmative defense, it's possible the judge could, say, well, unless you post the money for what you owe, I'm not going to let you raise that as an affirmative defense. Okay. There's some other defenses. You tendered the rent and the landlord refused to accept it. The plaintiff is not your landlord. Okay, so this happens quite a bit. For good business reasons, sometimes, a person, there's a corporation or LLC, limited liability company, that actually owns the property. Okay, and there's often then a separate company or corporation that maybe manages it, right? But maybe the same person sort of controls both of those. So sometimes that person may be the one suing you, right? But they're not your landlord. You don't have a lease with that person. Or sometimes maybe the property was sold and you didn't get notice of who it was sold to. So those are some things. Also, if the landlord is a corporation, they have to be represented by an attorney in court. The owner of the corporation or the director, an officer of the corporation cannot represent the corporation in court. They have to have a lawyer. And there's some others here too. As far as claims to be the new owner, and there's some protections if the property was foreclosed. There's also issues. Maybe you owe the landlord or the plaintiff is claiming you owe sums other than rent. So now, in a rent possession action, there has to be rent owed. Now, the landlord can add things like late fees or other fees. A lot of times I see fees for like litigation fee because they had to file a case or something like that. And those can be legitimate, but they have to be broken out from the rent, and they have to also, the landlord can only get possession for non-payment of rent. If you just owe fees and no rent, then legally the landlord should not be entitled to possession. And that's sort of the 9-2. Also, in a rent and possession action, they cannot bring a claim for damages, for property damages. And that's specifically in the statute. So the other type of main, of, I don't know why it's doing that, I'm sorry, but the other type uh, of unlawful case is unlawful detainer. I don't know why it's not staying. I guess I got an automatic thing on there. I'm sorry about that. So so unlawful detainer is different in that it's not really claiming that you owe rent, and you may not. So it could be that your lease was either ended or was terminated or for some other reason, or in a case where maybe the property was sold. I mean, this could also be used for homeowners whose house was foreclosed and now the bank or whoever bought the property on a foreclosure sale is trying to evict the thing. So it can be used in other things other than just the landlord tenant. So now, and this is where the distinction on affirmative defense versus defenses sort of come into play. So you can't actually file an affirmative defense in unlawful detainer case. So the implied warranty of habitability does not apply in an unlawful detainer case. And sometimes, landlords will file both. They'll file a rent and possession count and a unlawful detainer claim in both cases. So now there are very specific rules when it comes to how a lease is terminated, and it's going to be governed mostly by the lease, what it says in the lease on how to terminate it, but also by statute. And there are different types of leases, and they're terminated differently. Okay. So the most common type of lease is probably a month-to-month lease. Okay. And either the landlord or the tenant, for that matter, can terminate a month-to-month lease on 30 days notice. Now, the way there's some rules on where that 30 days comes from. So it's not 30 days from the day you get the notice. It's 30 days from when the next rent payment is due. So if your rent is due on the 1st, so the day is the 8th. So if you get a notice, your rent's due on the 1st, and you get a notice today from the landlord that they are terminating your month-to-month lease, the earliest it can terminate it is the end of December. Okay. But if you get it on November 30th, it's the same thing. So depending on when you receive the notice, you could have almost 2 months or just over a month, to vacate. Okay. Now, that statute that governs that can be modified by the lease. So, so we see that issue a lot too, where there may be separate language in the lease that that changes how the lease can be terminated. Now, a year lease is entirely different. Sometimes you see leases that are for 1 year. Now, the important thing with those is that a lot of them say it's for 1 year, and then after that, it's a month-to-month. Okay. Or it could say, it terminates at the end of the year and doesn't renew unless both parties agree that it's going to renew, or that maybe you have to give notice to the landlord that it's going to renew. So these are all issues that could come up in a unlawful detainer claim, because if the lease was not terminated, right, because the judge is determining whether or not you have the current right to be there, right? So if the lease was not properly terminated, you still have a right to be there, okay? And on a month-to-month lease, if it's, if it doesn't follow the statute, it's not like, okay, well, you knew about it anyway, you still have to go. There's not constructive notice, what would be called constructive notice. It has to comply strictly with the requirements, and if not, it's like it didn't happen. So it's not a situation where, well, you knew, it wasn't quite right, but, they knew they should have been out. That doesn't count. Okay. Um, so anyway, and so like it really depends on the lease and the statute. Like a year lease, if it's a year-to-year lease, I mean that has to be terminated uh, at least 60 days prior to the end of the term. End of the term. Another thing with if you own the mobile home or have an ownership interest, like you're buying a mobile home but maybe don't own it outright yet, and are renting the land that the mobile home is on, that 30 days becomes 60 days. Okay. Um, it's not a lot more protection, but it's some more protection. So in that situation, you get a little bit more time to think. So these are all things of ways, to pick at and find uh, defenses to the termination. And these are often successful because I'll tell you, landlords have a lot of rules usually in their leases on what you're required to do. But in my experience, they seem to have a hard time following those rules themselves. So we can often make successful claims on this. So also, um, um, so I see a question there that sort of, I'm going to just answer it live about, so just to clarify an earlier point, a landlord cannot evict a tenant over late fees or property damage owed just on lack of rent payment. So based on what I sort of said, yes. Okay. So however, the property damage or the late fees, like not paying rent on time for a regular basis, that could be a reason for the landlord to terminate your lease. Okay. So if you're behind on rent a lot or whatever, but you would have to have a termination notice. You would have to get some sort of termination notice that would comply with the lease and the statute to terminate your lease. Okay. So, but in the context of a rent and possession case, that is absolutely correct. The other thing with notices, like how they are sent. Okay. The statute just requires them to be in writing. Okay. So I think that includes a text message or an email. Okay. It's an electronic, but it is in writing. Okay. I think that includes something taped to your door. Okay. However, um, the lease may have requirements on how notices are sent, that are not always complied with. It may need to be signed. It may need to be sent certified mail. Okay. It may need to be delivered in person, So these are the things that when it comes to, now, not that you should ignore a notice that is not delivered properly. Okay. Because even if you think, it's not done correctly, the landlord probably does, right? And it's going to be up to a judge to determine whether or not it was done correctly or not. So anyway, so I'm spending a lot of time on this, but it's an important topic that I don't want to, it's one of the more important things or whatever. So right. The other thing too, when it comes to termination notice, is that you didn't violate the lease, right? I mean, they could send you a notice. Uh, 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 if you didn't actually do what they said in the notice, uh, you know, like it claims you had somebody living, like you get a notice that you had an unauthorized somebody who wasn't authorized to live there living there, okay, but you didn't, I mean, they still have to prove that you actually violated the lease, okay. Um, and usually the lease, the notice and something like that usually has to say what you actually did, okay. It can't say you violated the lease because you have no way to respond to that, okay. um, Now when it comes to termination notices too, okay, this is where a lot of people can get in a jam, is when um, let's say you got a notice and you talk to your landlord and, or the property manager or whomever, uh, and they say, well, you go and say, hey, can I get another month? I can be out by this date. They give you some sort of well, let's see, try to be out, something like that. Or they'd say, yeah, I'll give you another month to be out. Okay. If it's not in writing, it doesn't matter. Okay. And no matter what the landlord tells you, if they're going to give you more time to be there, you need to get that in writing. Okay. Because if you don't, it just doesn't matter. And in fact, the statute on unlawful detainer specifically says you can't bring that up, that any like verbal evidence or what's called parole evidence or would not be allowed even to be admitted for the judge to consider unless it's in writing. Okay. And also, if you pay your rent, let's say you get a termination notice that you're supposed to be out by November 30th, and you pay your rent on December 1st, and the landlord cashes the check or takes the money, that is not an extension or a waiver of the termination notice. So accepting rent is not going to waive that termination notice. So we kind of went over this a little bit too, but I just want to reiterate it because it's important. So so when if the landlord's file, you're going to know because you're going to receive a summons, and it'll have a return date, and it must be served 4 days before the return date, okay, which is not a lot of time, okay. Now, there are different ways that you can be served. So the most typical way is the sheriff's deputy or a special process server comes to your door, hands you the summons and the petition, and then we'll file a return, okay. It also can be mailed by first class mail or posted where it's taped to the door, okay. And sometimes the landlord will request all three, okay. Now, the difference with if it's done through mail and posting is if it's services through mail or by posting, then the landlord cannot get a money judgment against you, right? So no matter how much money you owe, they can't get a money judgment against you. So this, in some circumstances, if you're moving already, and you owe rent, right? And you think the landlord is going to be successful, but you weren't personally served, and you're going to be out, you might consider not going to court, right? Because if you show up in court, there could be a money judgment because once you make your appearance and show up in court, the court would be able to enter a money judgment against you. So I would, you want to probably talk to an attorney before you make that decision, but that's a possibility. That is the difference between the biggest difference between personal service or by mail or what's called substituted service, which is mail or posting. So defenses, evidence, and counterclaims. Okay, we talked a little bit about this. Defenses should be in writing, and you have to file a copy of that with the landlord and, or the landlord's attorney if they're represented by an attorney. So bring your evidence to court on the trial date. Okay, so I will tell you this, a lot of courthouses, you can't bring your cell phone in. Okay. And a lot of people, everybody's information, text messages, stuff like that between you and the landlord are going to be on your cell phone. Okay. If you need to know before you go to court if you're going to be allowed to bring that in. Okay. And you may need to print those off or have them there, ready to be. But I have seen a lot of people in court where they say, well, I have, I can bring it in later. You should have it with you on the trial date. Okay. Now, in a written possession case, unlike an unlawful detainer, you can file a counterclaim. Okay. So this could be, if you believe your landlord has breached the lease and or sort of had some sort of damages against you, it is possible to file a counterclaim. It's sometimes not the best thing to file a counterclaim. You may want to file a separate action. You're not required to file a counterclaim if there is one. There are no mandatory counterclaims in this process. And again, that counterclaim has to be provided to the landlord or their attorney if they're represented. And counterclaims are not allowed in unlawful detainer claims. So judgments, okay. So a default judgment, if you don't show up on the return date or any subsequent date, a default judgment is going to be entered against you, okay? And default just means you didn't respond or answer, okay? And if you show up, but your roommate or wife or husband or spouse do not show up, there might not be a default judgment against you, but there will be against your spouse, okay? I see it all the time. And I know it's hard. I'm not, if you have children at home, you had a job, it's hard to get to court. I understand that. Now, I know there are some courts that are still allowing, it's called WebEx. It's sort of like Zoom, but it's called WebEx. Allow appearance by that. I know the Warren County and Montgomery County allow that. I don't know about other places that are allowing that, but that's a possibility, but you can't necessarily rely on that. Now, I think if you file, the thing about the return date is that some judges will take up the case that day, okay? Not all, not most, but some will. If you appear, right? So, however, in both of these type of cases, if you appear on that day and request a continuance, the judge is required to grant it. Okay, not that they always do, but they are required to. Okay, so now it's possible that you could maybe, using the mode of tenant help, file a request for continuance and not appear, okay? But you're sort of taking a chance there that the judge is going to accept that, okay? Anyway. And somebody just pointed out that St. Louis County also allows appearances via WebEx also. So that's good to know. So yeah, so I think that's the important thing is that I often advise clients about what I think is going to happen or whatever, or what the law requires, but it's ultimately going to be up to the judge who is making the decision. I mean, that's their role. They're the judge, right? They determine, what's going to happen. So it could be that filing a motion to continue prior to, a written motion to continue, not calling the clerk's office and saying, hey, I can't be there, 5 minutes before the docket, right? But actually filing a motion, to continue, that should be granted. But, how I advise my clients is it worth the risk not to show up? Because the risk is a judgment is going to be entered against you, okay? Sometimes you might file it far enough in advance that you'll know if it's continued ahead of time, and you can check CaseNet and find that out. Now, a default judgment can be set aside, okay? So to set aside a default judgment, generally, you have to have just cause, which is a good reason why you weren't in court, okay? So a good reason could be, I filed a motion to continue and I thought it would be granted, maybe. So I was in the hospital, now, or it could be, I was there, but I didn't hear my case called or something like that, right? So, and I will tell you, not only go to court, but be on time. Because often these dockets, they're the largest dockets that the judge has to deal with. And when I say docket is there are usually, sometimes hundreds of cases, or tens of cases on a day at the same time. So it may be, in Franklin County, there are Tuesdays at 1 o'clock. That's where I practice a lot. So, if you're there at 1:15 and the judge has already called through the docket and you weren't there already could be a default judgment entered against you. Now, does that happen routinely? No. And usually if you're there, you say, it'll be okay. But I mean, you're taking a risk that a default judgment is going to be entered against you. Okay. Now, like I said, a default judgment could be, but you have to have a good reason, and you have to have a meritorious defense, which is a reason you don't owe the rent in an unlawful detainer or a rent possession case, as an example. So a good reason why you weren't there, just cause, and a meritorious defense, a reason why you don't owe, or a reason why the lease wasn't properly terminated. And you have to file that, and it has to be filed within 10 days. Now, I will say this, they're rarely set aside. I mean, it's not unheard of, and maybe other people on the panel have different experiences can say so. But also, the statute that deals with this is not really clear whether it has to be just filed within 10 days or whether it has to be filed and set aside in 10 days. Okay. So that's an important distinction. So, but the thing of it is, I mean, go to court, right? If you can, go to court, no matter what your landlord told you, if you can, you should go. Consent judgments. So I'll talk generally about this. So consent judgments are judgments that you and the landlord work out some sort of agreement, usually for you to pay off the rent and stay. Okay. So often I'll say, let's say you owe, $3,000 of rent, and, you're going to pay your current rent and then make additional payments. And as long as you keep current on your rent and make those additional payments, then, there's going to be, there's going to be a stay of execution, and that will not be, then you'll get a stay if you make all the payments. The problem with them often comes when, like, you pay it off, but maybe the landlord doesn't file what's called a satisfaction of judgment that it's not been paid, or that it's been paid. And then maybe the landlord will try to file an execution to have you evicted on that judgment that may have been already paid off. Okay. So when you have one of those things, it's important to, if you can negotiate it, make sure it's like, they will file a satisfaction. I mean, they're required to anyway if it's paid, but just so the court knows, because the court doesn't know. Like, the court will sign the consent judgment, and then the parties go on their way. The court doesn't monitor it, right? The court's not going to check to see if it's been paid or not. That's up to, if it's been paid, for the plaintiff or the landlord to file a satisfaction of judgment. Okay. So those are the same things to consider. And I want to leave some time for questions if there's going to be more, but I'll have some more stuff. So at trial, you have the right to a trial. In some circumstances, you have the right to a jury trial. You usually have to request a jury trial before the return date, but there is that possibility in both these type of cases. There are some downsides to having your jury trial, because if you lose, you're probably going to have to pay the cost of the jury trial, which can be substantial. So bring your evidence to court. You have the right to testify, and you may ask witnesses to testify. So usually what you can't do is have a statement from a neighbor or something like that where it's written, even if it's notarized, that's probably not going to be allowed as evidence. If you want to subpoena somebody to testify, they use most clerk's office. You can go and ask for a subpoena. Now you'll have to pay for service, but the sheriff's office will often do that. I mean, you'll usually have to pay for it in advance too. Or if it's somebody you know, you can bring them along with you and call them as a witness. If you lose a trial, a judgment will be entered for rent and other damages, or in an unlawful detainer, it's actually double the rental value after the lease was terminated. One thing about rent and possession judgments, if there's more than just rent owed, so if there's rent plus late fees, maybe attorney fees and court costs, that has to be itemized, okay? And if it's not, if it just has one full amount, then it's not actually executable. I'm going to talk a little bit about what that is. So also with a rent and possession, now these two things are not available in a unlawful detainer case. So in a rent and possession action, you have the ability to pay and stay, okay? And what that means is if you tender the rent owed on or before the trial date, then the wording in the statute is all further action shall be ceased and stayed. Okay, so if you pay it before the trial date, you know, that should be the end of the case. Or within 10 days after a judgment is entered. So let's say you don't have it on the day, right? And there's a hearing, the judge determines what is owed, the whole amount. And if you're able to pay that whole amount within 10 days of the judgment being entered, then the same thing, the action is ceased and stayed. Okay, and so those are what we refer to as the pay and stay provision. So, those are important things to remember. And also, when a judgment is entered, it's not necessarily going to be the day the case was heard. It likely could. Often judges will say, well, I'm going to take the cause under advisement, and I'll issue a judgment. Now, you know, the judgment may be entered later that day, okay? Or it may be a week, you know, in some cases I've had judges take a couple months to enter a judgment, you know. But once that judgment is entered, you have 10 days to pay it. And if you don't, well, it's not really in the slide here, but so what happens if a judgment is entered and you lose and you're not able to pay or in an unlawful detainer? So there's a 10-day period from the time the judgment is entered for you to file either an appeal, possibly, or a motion to set aside a motion to set aside the default judgment. Now, if you appear and the case was heard, right, and there was evidence presented and you were there, that's not a default judgment. Okay, that's what's called a judgment on the merits. And the rules for setting aside that are different than setting aside a default judgment. So you don't really have that option for setting aside a default judgment if the case was actually tried. But once the judgment, after that 10-day period, the plaintiff, the landlord, can request execution, okay? And what execution is the sheriff's department coming and removing you from the home, okay? So it varies from county to county and the sheriff's office from sheriff's office. So that 10-day period runs, and depending on the landlord, if they file a request for execution, and it's going to be granted fairly quickly, and it's going to go to the sheriff's office. Depending on the sheriff's office, well, to answer, there's a question in the chat. How much does the money judgment cost? I mean, it depends on how much you owe, you know, as far as what the judge determines you owe, whether how much rent you owe or how much damages in an unlawful detainer claim, how much you're going to owe. So it really depends case by case. All right. Anyway, so and some sheriff's department, they'll put a notice on your door and say, hey, we're going to be out in a day or 2 days, and if you're not out, we're going to remove your stuff. Okay, and you. And but they all handle it a little bit differently or whatever. But that's that process afterwards. Now, when it comes to so appeal and a rent of possession is not really an appeal. It's called a trial de novo, which means it's just Latin for new trial. So it also has to be filed within 10 days after the date of the judgment. Okay. So if it's a default judgment, you still have a right to a trial de novo. So it might be you file both, a motion to set aside the default judgment and a request for a trial de novo. So here's the thing. There's going to be a filing fee, could be waived. The biggest thing with a trial de novo or an appeal of an unlawful detainer is that even though it's being appealed or you're going to get a new trial, that judgment that was entered is still good. And unless you post a bond or an amount of money for the amount of money owed under the judgment plus rent that accrues, right? The landlord can still execute and have you evicted, even though that appeal or trial de novo is still pending. Okay. So it's not, if you're in this position or whatever, it's not really, a good position to be in. Okay. Because, I mean, now if you have a good, like if there's a good thing, like, oh, I didn't really owe this rent, but I have it, and you can post it, that's great. But if it's it's probably better just to pay the rent and get rid of the judgment than to do a trial de novo. And that's my opinion. You need to talk to an attorney about that in your particular situation. All right. Appeal for unlawful detainer is a little bit different. It does not get a trial de novo. It has a direct appeal to the Court of Appeals, but it still has, the same requirement of a bond to stay execution during the pendency of the appeal. Okay. So I'm going to apologize. I just realized I had a little typo there. But anyway, so these are some different resources out there. So the first one is motenanthelp.org, which is the one that Terry and John Boyer did last week on how to do the forms on that website, and the QR code is there. So if you're watching that, I mean, you can link to that right there from that QR code. And the other is Legal Services in Missouri.org, lsmo.org. So that's the website. If you're, because this is statewide, there are 4 different legal services in the state. So you're not sure which one is represented or would be able to assist you, you can go to that website. It'll give information on how to contact the legal services, which are Legal Services of Eastern Missouri, Mid-Missouri Legal Services, Legal Aid of Western Missouri, and Legal Services of Southern Missouri. Will direct you to the correct one. So that's the end. I'm going to just leave these up here. So if people want to follow that QR code, they can. Those QR codes, they can. I do have some time left for questions. I don't see any pending questions in the question and answer, but I'll stay on until 1 if people want to post other questions. Okay, I do see some questions here. Okay, there's a question here about eviction as a nuisance. So a nuisance is probably going to be a violation of the lease. Okay, so I'm assuming that's sort of what you mean by that. So if there's something on the property Now this presentation is just regarding residential leases and residential evictions. Is not to deal with, you know, business leases or anything under that. Because nuisance, when I hear nuisance, I think more of like, um, you know, something where, you know, there's something chemical process that's causing a stink or something like that, you know, that's a nuisance or whatever. But a nuisance would generally fall under, if it's done by the landlord, would be a breach of lease. Um, uh, okay, so there's a question: does a landlord need to terminate uh, the lease before filing for eviction if past due rent is owed? Okay, um, so okay, uh, no. Uh, so if you owe rent, the landlord can file a rent and possession action, okay, which is that you owe rent, and if you don't pay it, I want possession, okay. If they file an unlawful detainer action, I believe that there'd have to be some sort of notice that the lease is terminated. There is sort of a older process called forfeiture, which says, but that there's very specific requirements that are hard to understand that usually do, but there would have to be some sort of notice that say, uh, okay, unless you pay all, that's the exact amount of money owed and everything on that day. So that's a possibility. So, uh, but to answer the question, um, does not have to terminate to file a rent and possession action, but would have to terminate to file an unlawful detainer action. I think that answers your question. And I'm just, well, sorry, I'll leave that. I want to make sure that's up there. Uh, you're welcome. Somebody just posted that in the question and answer. So I just, the biggest thing as far as takeaway is this, is just don't rely on what the landlord may have told you, or, you know, go to court if you receive a summons. Also, um, you know, I've never seen, okay, there's another question here. So in the case with rental, if a client has a judgment for eviction, the landlord can accept our portion and the judgment still stands. Not, I don't know. So I'm gonna say, like, so you have a housing choice voucher, Section 8 voucher, and so I'm not sure if, so if it's a housing choice voucher, if the tenant has paid his or her portion of the rent, okay, generally the landlord cannot claim that the housing authority has not paid their portion, okay, because that's a separate contract between the landlord and the housing authority for payment of the thing. I'm not sure that's your question, but I think so. Yeah, and also that motenanthelp.org is more than just uh, uh, how to make forms, you know, like a motion to continue or whatever. It also has a lot of information in there about this process. Um, you know, so there's that. So anyway, we still got about 5 minutes. I'll stay on to answer any other questions until 1. Um, okay, there is another question. Could you address the part again where you said that you could ask for jury trial? Okay, so in a lot of cases, like in both rent and possession, And a lot of, as far as a jury trial. So um, in each of those cases, you have a right to a jury trial. Now, your lease may say you're waiving a jury trial, and that may or may not be enforceable. Okay. If you're in public housing, you can't waive that right to a jury trial. Okay. Um, so, I mean, a lot of people will request a jury trial because it'll take longer, right? A judge is going to hear the case right away. It'll take longer uh, to hear a jury trial. So some of the pros and cons in that situation, and you would need to talk to an attorney before deciding this. And this is just general information. Um, so, but I mean, if it's an unlawful detainer case, I mean, the damages are double the rental value for the period you hold over. Okay. So if you lose and it took you 6 months to get to a jury trial, you're going to owe double rent for 6 months. Okay. And the court costs are going to be a lot more because you had a jury trial. So there are a lot of, so that's something that can't really be answered in this, in this, in this presentation. And I encourage everybody to, the other thing too, just a practical advice. Um, I'll just, be honest with everybody. If you call us the day before the hearing, um, we're probably not going to be able to help you. Okay. So when you get a summons, you should be looking for help as soon as you get it. Okay. Whether you're going to hire your own attorney or you're going to file a continuance, or call one of the legal services in Missouri. The sooner you contact us, the more likely it is we're going to be able to help you. Okay. And also, if you call us after a judgment's already been entered, there's often not a lot we can do. Okay, other than just like, hey, this is what you need to do. So it's important to, and I I know, I mean, sometimes it's hard, right? You're trying, you're trying to work, you're trying to take care of the kids and all that kind of stuff. And and maybe you think you have a good relationship with the landlord, and the landlord says something like, or the management, but you may have a good relationship with a property manager, but maybe they're not the one deciding whether or not to file a lawsuit or not. So it's just important to go to court. So we got about a minute left. I hope this was helpful to people, uh, you know, and I hope you use the resources that are available. And so, but I'll wait until the end here, and then but this, and we have a presentation on fair housing next week, which should go. I don't think I can think of anything else. There's one question. Anything else to know before we go? I would just say go to court and use these resources that are up here if you get a summons. Okay. All right. It's 1 o'clock, so I'm going to stop sharing and end the thing, but this will be available.